My Lords, we were at MS page 376 before doing that. Can I just raise 2 points of correction in response to questions from my Lord Briggs?
Sorry, say it again. You were speaking rather softly.
Forgive me. 2 points of correction.
Right.
First, the threshold, my Lord, for the amount is now, the relevant amount is £10,000.
Still a bit below what we're concerned
Yes.
with.
Yes. And the other point is that the application to change the representative member is now in section 43B, subsection 2C, which is not before your lordships, but there's no material change from that in the old
43 big B, yeah?
big B,
2 little c.
2C.
And it's
there's
in the
no
same form as
Yes,
section 29,
yes.
whatever it was you looked at.
Sorry, 43, is it?
Section 43B,
43B.
Capital B.
Big B.
2
2C.
subsection C.
Thank you.
So apologies for that not being in the bundle, but it's no real change. We were at MS page 376, the first of the claim letters. And I just dealt with the point that it was using the group's vet registration number and it was on a protective basis prior to Fleming, and also made the point from the third paragraph that it was distinct from the prior claims made by Carlton, which were limited to a 3-year period and would have been necessarily personal to Carlton. And that's clear from the second paragraph, where there's a reference to the current 3-year cap. This claim goes back further in time. It's clear from the schedules at page MS 378. It goes back to 1973. It therefore necessarily engages the right to repayment of the single taxable person, of which Carlton had been an erstwhile member.
Well, is that necessarily so? I mean, if there was an assignment, then the right would be the assignee's right, even though it was originally generated as a group right. If, as a matter of law, once you leave a group, you acquire in your own right a devolved claim, then, again, it's your devolved claim, isn't it? So it depends how you look at it.
Well, for present purposes, I'm simply seeking to construe the terms of this letter.
No, but we've got to construe the terms of this letter against the general understanding of surrounding circumstances at the time. And if one doesn't know, the only purpose of Carlton making a claim would be because it had some personal interest in respect of pre-1990 repayments.
Yes.
And that personal interest could derive in a number of ways, but one is assignment, one is whatever the arrangements were when Carlton Clubs was brought into existence, which is probably more or less the same thing as the slightly broader head than assignment. And a third is, I suppose, that I don't know, some sort of automatic devolvement of the right, though that's a bit more difficult here when it wasn't a member between 73 and 90. But the first 2 points apply. I mean, you've got to ask why commercially is it making this. Presumably it is because either directly or indirectly it has some personal interest. And if it may have a personal interest directly in its own name, then it may be treated as claiming on its own behalf.
I would distinguish, my lord, between the nature of the claim and who is seeking to be paid it. Because on the assignment point, your lordship posits, the claim would be properly that of the single taxable person, but by dint of the assignation is payable to Carlton.
That's, if I may say so, a slightly obscure way of putting it. The assignee acquires the right to the claim, even though originally it was the assignees. So,
yes.
Assignor, so it's no longer the assignor's right.
Well,
it's the assignees. And the assignee claims on his own behalf.
he claims entitlement to be paid, but the assignee would not be able to take that assigned right without the as it were, the fiscal accoutrements attaching to it. For example, there may be an assignment of a claim to output tax, but one can be quite sure that the Crown would not permit the assignee to recover that if the assignor had not...
Because assignees always take subject to the burden. If there's some set off, then there isn't anything to assign.
But once in Scots law an assignation is intimated, the right is the right of the assignee. And he may take the assignor's right subject to the burdens, but they're his right. It's his claim, and he's entitled to payment. That's the way the law of assignation works.
But forgive me for querying, but at this point in time, as of November 07, two things are clear, as we now know. One is there was no assignation, so no rights have been assigned as in fact. The second is there's no reference to that in this letter.
No, but so why are they claiming? Why are they claiming them in respect to this early period, unless they have some economic interest?
Because, my lord, they are claiming expressly by reference to the VAT registration number of the group, which has that interest back to 73, and it was a member of that group. It therefore has an interest in so doing, and that's why it's exercising the group's right. It's not saying, I'm an assignee, here is my VAT registration number.
Well, it's doing it out of, one must assume that the group regulates repayments correctly, namely, it gives the benefit of them to those who made the overpayment. Absent some other explanation, this letter is pure charity.
No, surely as long as it's got some possibility of receiving something on it, it's worth making the protective claim. Otherwise, no one gets anything. But if it assumed there was a right which it might have an interest in.
And it being its interest in the rights of the single taxable person.
And as the trader, which had presumably generated what turned out to be an overpayment of VAT within the group, it would, within the group, be the entity with the greatest interest in making sure the claim was pursued, presumably.
That only applies to 1990 on. We were discussing 73 to 90.
Yes.
That's what's puzzling me.
There's an issue about colouring this letter with the later revision.
Yeah.
One is looking at this letter, it uses the VAT registration number of the group, and therefore, as one would expect with a group claim, it concerns periods going back in time before this entity even existed, but of no concern to the revenue, because they say, why is it going back to 73? Because it's a group claim, because that's the VRN I've used to query it. And in terms of the basis of the claim under Section 80, which I'll come back to, there's no intimation here that Carlton personally has an entitlement in the sense that it made the overpayments, because it's quite careful in the 5th paragraph at the bottom of page 376. Although it talks about our claim, that claim, of course, is because of overpayment declared on the returns. It says the schedule set out the output tax which were originally declared on VAT returns for the respective periods. So therefore, the reviewer of this letter, the revenue, goes and checks those returns for the period. They are submitted by the representative member on behalf of the single taxable person. That is my client. That tallies with the VAT registration number on the top of the document, with its name to boot.
Yes, in that case, but you did start at 376. If you go back to the earlier letter, you got the same VRN, but Carlton's name.
One does, my lord. I'm going to come on to that because...
and also you have in 376, to which on which you're concentrating, in paragraph 4, this further protective claim therefore serves to extend the scope of the previous disclosure. If it's a claim of a totally different nature, why use that language?
Well, if it's going to be suggested that this is a mere extension to a pre-existing claim, one could rest assured that would have been rejected, because the idea that if there had been a claim put in for quarter 1 of 2006 because of a mistake, and they then wish to put in a claim going back to quarter one of 1973, that may well derive from the same mistake, but it's going to be met with the response that that's a different claim for a different period. So there were indeed different periods going back 3 years, and it may well have been on the same mistake, but this wasn't just an adjustment. They make quite clear that this was a submit protective claims. They're not saying, can we just tweak the basis of the prior claim?
No, I wasn't suggesting that. I'm sorry if I gave that impression.
Forgive me if I misunderstood.
What I was suggesting is that that paragraph is suggestive that the claim is of the same nature as that which has gone before.
Well, if your lordship's suggesting the same juridical basis in terms of entitlement, then I would disagree.
Yeah.
If your lordship were to suggest that it suggests it's of the same nature in terms of the same fiscal mistake, I would agree with your lordship. Because if the mistake is these extend the prior claims because they've overpaid on bingo supplies where there should have been no VAT, it is exactly the same mistake.
Yes.
It is exactly the same mistake. The difference is that a different person made it, because post 1998, that mistake was made by Carlton with its own independent fiscal persona. In the periods in this letter, namely 73 to 96, that mistake was made by a different fiscal persona, a single taxable person.
Thank you.
You have my points in the written case that one can derive very little from the use of the first person plural. As my Lord Man's pointed out, it does refer to our client, which if one's taking a literal meaning, therefore points in the opposite direction, rather than pointing to whether we claim or our client. If one looks to both the substance of what is being claimed and the periods in conjunction with the premise on which it's claimed in the heading with the VAT VRN, that, in my submission, points to what the claim is and who it belongs to. I've nothing to add to the letter for the mechanised cash bingo claim at page MS 380, which is in materially identical terms and exactly the same points arise. As my Lord Hodge pointed out, and I wasn't trying to avoid it, but then progressing through the claims to the participation fees at page 372, which no doubt for good forensic reason my learned friend went to first, for your lordships, that does refer to Carlton in the heading. But that doesn't detract from the fact that it may refer to Carlton Clubs PLC, but the VAT number is not Carlton's number. It has its own VAT number, not identified on this document, but it's still adopting the VRN which it had used during its membership of my client's VAT group.
Can one find any explanation for the use of Carlton clubs here, except a failure perhaps to adapt the pro forma or which was used for the previous claim? I mean, has anyone suggested any logical explanation for the use of the word Carlton Clubs PLC here rather than Taylor Clark?
Not that I'm aware of, my lord, and there's been no reference in any of the decisions below as to the reason, because your lordship points out 3 of the 4 refer to my client with my client's VAT registration number. 1 of the 4 refers to Carlton, but with my client's registration number.
I mean, they're all overpaid VAT, aren't they?
Yes.
They're all the same, roughly the same period.
Yes. So one sees it.
Does the heading, whether it's Taylor Clark or Carlton Club, let's assume it's Taylor Clark and that this is just an error, and the VAT number, how far does this help you? Because you'd have to identify under what aegis the VAT was paid. These are all claims for overpaid VAT. So you have to say, this is where they were overpaid, even if you were making a personal claim yourself to recover, wouldn't you? So can one draw an awful lot from the use of that aegis?
In the context of VAT, by putting the VAT number at the answer of that letter is a very clear intimation to the revenue that this is a claim under that VAT number. This is not simply to To step back for a
claim in
moment,
respect of VAT paid under that VAT number, that's certainly true, but it's said to be overpaid, and then the question we have to decide is who and in what capacity is the claim for repayment being made? By whom?
the VAT number is very specific to the individual and is not to be used by any other. And one is obliged to put on the number when making the claim. There's no reference in either of these four documents to Carlton's own VAT number. Put another way, it is not seeking a credit to its VAT account. What happens is the use of my client's VAT number.
Would you need to? I mean, if you don't go through the procedure available for sums up to 10,000, if you're owed 100,000, can't you just write to the revenue and say, I've overpaid, here is the explanation, please send me a cheque?
One could say that, and there'd be a sharpish response back, what's the VAT number? Because without the VAT number,
They only
the user
remit
can't be
to a VAT
identified.
number, would they? Yeah.
Because there
The
is...
first thing that the person in the revenue dealing with this letter would do is match the APM column, I think it's the APM column in the table, which again has the same VAT number,
Yes.
with its own records
Yes.
to see that it corresponds with declarations that had been made historically, in this case by this VAT group.
Yes.
Yes. I mean, the VAT number will need to be, whoever had the claim, one would need to know the VAT number in order to ascertain whether the sums had been paid and the validity of the claim that there was an over-declaration. So the number had to be there, come what may. But you say, with some force, well, the only account to which the claim was being made, which had a bank account attached to it, was the very account declared, and indeed the revenue paid money into
Yes.
your account on one occasion.
Yes, it did. Because what then, John, waste time by going to it. Claims like this, when repaid, generate a pro forma document showing the VAT account by reference to the VAT number, which shows a credit of the amount claimed pursuant to the VAT number, and that's what my client received, and that was the first indication of the payment in response to this claim.
But I suppose, I mean, if the revenue was thinking along the lines of triad, as you apparently were, then what it should logically have done would be credit the Taylor-Clark Leisure VAT number, but actually make a payment separately, not to the Taylor-Clark account, but to Carlton, if it saw these letters as a claim by Carlton.
Yes,
But
there would be a manual override, as it were.
Yeah.
But if that were right, and one were proceeding on the false premise, as per triad, that on the disbandment the right somehow devolves, you have my submissions that right is the right of the single taxable person, which via some undefined route somehow devolves back to the individual. But that means the individual is able to exercise the group's right. Now, it's very difficult to pursue that further with the Lordship because everybody accepts it's wrong, and bar the first tribunal's decision, and another, that in that case, neither side accepts is right, the contours of how the devolution of the right happens and the nature of it's not been explored. Short point is, they didn't have the right, it was a VAT group's right. And that's what was being exercised.
Everybody accepts it's wrong. I'm just looking at the first tier tribunal, but this is accepted on paragraph 67 of its judgment. I don't know where that is in the MS, but at a certain, yes,
MS 185.
185, that where a group was disbanded before a claim was paid, then you've got individual claims. That's a modified triad position.
Yes.
But is that accepted to be wrong now?
Mode, yes.
It is, yes. Yeah. Certainly between these parties.
Yes.
Yes.
Not
in the other litigation, though.
That's the Crown's position in the other litigation. It's disputed by
Yes.
some of the other
Yes.
taxpayers. But there was a change
Yeah.
in the Crown's view.
Yes. Right.
The only advancement in terms of explanation at the base of the claims comes in the revised claim at MS page 388, where there is a further explanation given by Carlton in respect of the two periods, namely the assignation for periods pre-1990 or triad timber post-1990. I'm not going to repeat what's dealt with in detail in the written case, but your Lordship will have my point that even though this purports to be an assignment, if I am right on my analysis of a single taxable person being the cumulative sum of its parts, and them having, as it were, commingled and tangled rights, and although there may be an assertion here by this taxpayer that my right to the repayment is because of an assignment, it doesn't matter whether that's right or wrong. There is a right to repayment, and he is entitled to bring it, because if I'm right in my submission, he was a member of that single taxable person with the right to bring it. I should just say in that context, it doesn't matter in my submission that a number of years has passed since Carlton was a member of the back group. Because the status...
So I don't quite understand that. There is an entitlement to repayment, but who has that entitlement if there's been an assignation?
If there were an assignation, and that were valid, that would be a right to repayment to Carlton.
Yes. And isn't that what this letter is claiming?
This is, well, you still have my points by reference to the Taylor-Clark VAT group number. As I must take the point that there's much further detail here to suggest that the claim is being made personally by Carlton, and an attempt by Carlton to benefit personally from the monies referable at least to this one of the four claims.
Yes.
I'm not going to go over what we'd said in writing about the fact that one can't construe the earlier claims by reference to later actions.
This may taint your claim to the added prize money, but you say it doesn't touch the others.
It doesn't touch us at all. But even in respect of this, it may indicate who should be the payee, namely Carlton. But even if Carlton asserted the wrong basis of claim, i.e. assignation, which gave rise to a right to repayment, when in fact it had a right to repayment by dint of being a member of the VAT group, my submission doesn't matter. He's still entitled. There's still been a claim, qua member of the VAT group.
Is it? I mean, if you assert, if you make a claim saying I'm entitled to this repayment, please pay, because I know you will only pay the third party. You're not making a claim on behalf of the third party, are you? You're making a claim which will benefit the third party, but and you may do so in reliance of the third party's duty to account to you. So there is a conceptual difference, isn't there?
Yeah, but in that context, there's the idea of a claim being made of the third party, and please pay the third party.
Yes.
I'm not going yet to the issue of and please pay, fill in the gap. I'm at the prior stage. What is the claim, and whose claim is that? And at that point in time, at that stage of analysis, what is being repaid is the overpaid VAT that has been overpaid by the single taxable person.
Yeah.
It, as a fictional whole, is entitled to repayment. Who can raise that right? Well, as an erstwhile member, Carlton can raise that because it used to share those rights as a member of that single taxable person, and therefore has one triggered a claim under section 80 and that's all one needs to do for these purposes, the answer is yes. Put another way, one can test it this way, for no doubt very good reason. If a claim goes into the Crown by a party entitled, they won't pay to a third party, no doubt to avoid payments to improper third parties and money laundering and the like. There must be a payment to the VAT account number, hence why it's put down there. But if a claim went in saying, I'm due this money, please pay it to my bank to set off the overdraft I've got with them, there would still be a valid claim being made by the taxpayer entitled to the refund, even though the payee was somebody else.
Sorry, I missed the example.
The example your Lordship posited to me was, this is Carlton saying there is a claim and pay it to me. And I say, well, that may be right, but the important step in terms of stopping the time running against the single taxable person is, when was the claim made? Who is to be paid doesn't necessarily matter. In the same way, the Crown will only repay a claim to a designated VAT number normally. If a claim goes in by a taxpayer who's overpaid and there's a request, don't pay it to me, pay it to the bank to set off the overdraft, the revenue won't do it. But it's still a valid claim by the person entitled, even though he asked it to be paid to a different payee. And here, there may be Carlton saying, please pay it to me, I'm a proper payee, but he was also able to say, the VAT group has a claim because I'm an erstwhile member, and that's sufficient to tick the box in the Section 82, which I'll come to in a moment, in terms of stopping the time running. Or put another way, what is clear in all these claims, even the revised, is that it was the right to reclaim of the single taxable person which was being asserted. And the point I was making a moment ago, it doesn't matter that Carlton had left the VAT group a number of years ago, because its status as part of that single taxable person, its fiscal status for those purposes, is intimately connected with the nature of its right. One follows the other, as it were, and therefore, by asserting the right, it is also enjoying the status it had when that right existed, namely as a member of the single taxable person. One can test it this way. When a business taxpayer joins the VAT group, it may maintain its corporate identity vis-à-vis the rest of the world, but it loses its fiscal identity. It no longer has a VAT number. It's a nothing in the eyes of the revenue as an independent fiscal entity, part of the single taxable person. It therefore can't make any independent claims. We know that from ampli scientifica. But if that entity had overpaid tax whilst an independent taxable person prior to joining the VAT group, that money can be reclaimed. But it's not claimed by the new VAT group. It's not claimed by the new single taxable person. Instead, it's common ground, that amount is claimed by the individual who, as at the date of claim, has no taxable persona, and it does so by a manual payment and gives the revenue its old VAT number, which now no longer exists, because that claim is peculiar to it for that prior period when it did have a persona. By imperative reasoning, here, when Carlton is putting in the claim by reference to that which belongs to the group, it will adopt that prior status, and therefore is properly treated as being a claim by the single taxable person. The next and last issue to deal with is whether, if I'm right so far, that is a valid claim for the purposes of satisfying the procedural requirements of Section 80. Now that is at tab 3 of the authorities bundle, MS, page 437. Now, in many respects, this is a very simple provision, simply where a person has accounted to the revenue for VAT that was not due, the Commission shall be liable to credit the person with that amount. The reason why there's no automatic set-off on the running VAT account is because of subsection 2, which is the Commissioner shall only be liable to credit or repay an amount on a claim being made for the purpose. Now, the Crown say, and this is the conclusion of their analysis, only the representative member can make a claim, which must mean that they are the person to whom the amount is liable to be credited for the purposes of subsection 1. Now, my submission, that can't be right. The liability to repay is to the person who has accounted to the commissioners. That clearly is not the person who happens to have repaid the money, because that could be directly from a loan from a bank, by a treasury company, within a group of companies. It's the person whose liability has been accounted to the revenue in terms of the VAT return. And we know from Ampli Scientifica, from the Ireland case, and from Scandia, the only person able to do that is the VAT group. So it says in terms, not independent parties, and it's not the representative member on its own behalf, it's a single taxable person. That is the notional fiscal entity entitled to the credit.
But under the legislation, it's the representative member who accounts to the commissioners.
That doesn't work either, my lord. One can't read it that way, because it takes a situation, not uncommon. There is a representative member in year 1 who makes an overpayment. In year 3, when that's realised and a claim is put in, there is a new representative member. It's not the same person.
Well, maybe in law we get back to the point we were discussing in the morning, don't you? Doesn't one treat the representative member as having a continuous character by way of succession, as one would if one was talking in other contexts?
Well,
of a corporation sole or a state succession, it's quite a familiar concept that someone inherits the relevant representative rights and duties.
but what your lordships they're edging towards is the creation of a continuing representative that is the single taxable person, and one's then transferring the fiction of grouping from the members to that entity by deeming that entity chosen by the parties to be the single taxable person, and saying that that member from time to time shall succeed to the rights of the prior member. Now, one needs to do a considerable amount of violence to the language of the VAT Act to give rise to that situation. Whereas if one starts on the premise...
I'm not sure. I mean, again, we're discussing something we discussed this morning, aren't we? But doesn't your concept of a VAT group have the same effect? Because that group may expand or decline, but it still continues to account, including for things which may have taken place when its members were different.
Yes, but the...
So that, I mean, your concept is one of a continuing concept, just as the one I was putting to you.
The difference between them, my lord, is that what I urge upon your lordships is the notion of legal entities. One ignores their separate legal nature as companies under domestic law, and one treats them all as having one fiscal persona. And that's what the European Court has said time and time again, where your Lordship's proposition to me is to say one takes those legal entities and one ascribes all their activities to one of their fold, and I ignore them for all other purposes.
That's what Section 43 tells us to do.
Yes, and it, as Lord Nolan said, it may not be what it says in terms, but if it's there to give effect to Article 11 and the jurisprudence of the European Court, that's what it must be taken to do. Because otherwise, the rights which are said time and time again by the European Court, and I'll take your Lordship in a moment if I need you to Scandia, the rights of the members of the group, not the rights now given solely to one of their flock they have chosen. That is not the model. Article 11 is very clear. One can treat persons as a single entity. So one has a collective treated as a single taxable person. What one does not do is engage upon a further simplification, which is, and actually, I'm going to move all the rights and obligations to one and one alone.
Well, how do you know, under your European concept, who runs the single entity?
But that is a necessary predicate to satisfy the commissioners that there's eligibility to be grouped in the first place.
But I mean, I thought a moment ago you were saying that the commissioner's view was irrelevant, and it was a point I put to you that the UK scheme has been approved by the VAT committee, which consists of a member of the Commission and members of all the member states.
Oh, yeah, yes.
And presumably they thought it was all right. But I think you said one shouldn't look at what they thought.
But the point your Lordship is making is with respect to a different one. It's not a matter of whether the system works. Your Lordship's point was who controls it?
Yes.
And the answer is dictated with an excellent VAT group by reference to the very reason why it's there. There will only be a VAT group if the members on a cumulative basis have demonstrated there is sufficient control between them to meet the test set from time to time by the Crown. We have before the Court the test in still Section 29 of the VAT Act behind tab 1 page MS 449. And if one looks at page 450, the test is one or of them controls each of the others, or one person controls all of them, or two or more individuals carrying on a business in partnership control all of them. So that's the issue of, if one meets that test in terms of control, namely being able to corral the members together, one is eligible to do so. And if one's met that test, I think the point made by Lord Briggs this morning is problems usually won't arise in the context of an ongoing VAT group because of that very control. The issue only arises when there's a departure and one is then trying to untangle those rights which were merely corralled by dint of that control at an earlier point in time.
So if the two or more members, individuals carrying on business, and at a certain point having control, fall out among themselves, one doesn't know anymore who represents your VAT group.
Well, there will still at that point in time be the formal notification to the revenue saying one party here is the representative member, and until that's rescinded, that will still be there.
I see.
But one can see there's still, in that rather unhappy example, that there will clearly be a dispute between them as to who can make a claim if there's a dispute. Or the example I gave this morning, which is where the representative member happens to be wound up.
Yeah.
And then there's, as it were, some interregnum. It can't be right that one simply falls through the cracks. Because if the Crown's right, and take my example of a company being wound up, as in J&W Waste, and the Crown repays it. And it may have been said that if the company comes back onto register, if the Crown said, but you're not the right party, formally, could one just put in a claim by the rep member, one asks, well, what would the purpose of that be? But that's not done. It could have been done, but it wasn't. The Crown have got 2 years to make a clawback assessment in respect of amounts not due. And on the Crown's analysis, they paid the money that was due to the group because it was claimed by a member. It wasn't due under Section 80, and they're entitled to claim it back. That can't be right in my submission. That can't be right. And it's no answer to say, but in that situation, surely there's some form of implied authority on the part of the individual member to put in the claim. Well, no, because on that example, there's no representative, as it were, to confer. But in my analysis, one doesn't need to go down that route at all, because the member, by putting in the claim in the absence of a representative member, is simply exercising the rights which belong to that single taxable person of which it is a member.
Really, the whole argument hinges on the idea that by virtue of Article 11, you have a single entity and rights vest in that entity.
Yes. I mean, your Lordships will be aware of Scandi. If I could ask your Lordships to go to that, a very extreme case. It's in the authorities bundle, tab 37, page 1067.
Sorry, what was it?
1067, tab 37.
Yes. Yes. Yeah. I think we've got to try and move on with the time, but yes.
I'd ask your Lordships to go to paragraph 30 of that judgment.
Yeah.
Therefore, for VAT purposes, the services supplied by a company such as SAC to its branch belongs to the VAT group are considered not to be supplied to that branch, but must be regarded as being supplied to the VAT group. Forgive me, and the prior sentence, it's not to the member, but to the VAT group to which that member belongs. The court's not talking about joining and therefore it's all being, that they drop out of the picture fiscally. They join the VAT group. It's a member of the VAT group.
I mean, I think we've got the picture under European law.
Yes.
There is a taxonomy which is rather different from the British one.
You also have my points based on Thorn, where it is permissible to interpret the consequence of the deeming in section 43 to give the same result as that required by European law.
So that was tab which?
Thorn, my lord, will be tab 16.
Yeah.
And again, the relevant reference in Thorn was MS 623 letter E.
Yeah. That's Lord Neville. Right, where we...
Yes, one has to read that also with what appears between C and D, that the provisions are designed to simplify and facilitate the collection of tax.
Yes.
Yep. Yep.
And the only reason why it hasn't done so here is because one is in the position where somebody has departed and there's no longer the control to do so. But that simplification is not undermined by treating a claim asserting the right of the group as having been made on behalf of the group by a party with an interest by dint of its erstwhile membership. Because for this part of the argument, all one is concerned with is a very technical point. Do those claims satisfy the requirements of Section 80, subsection 2? Because that's a time-bar point being raised against me. And if they are made for the purpose, not otherwise defined. And that purpose is clearly that set out in section 80, subsection 1, namely repayment to the person, that is to my clients. I'm conscious, my lords, of the time.
Yes.
If I may, let's assess further, ask Mr. Simpson to address you.
No, I think. Thank you very much indeed, Mr. Soren. Yes.
My Lords, as I intimated at the start of the respondent submissions, I will make submissions on the second point, which is whether at general law Carlton acted as the agent of the Taylor-Clark group, and whether Taylor-Clark is allowed to rely on the claims Carlton made on that basis. And of course, my submission is really a response to that of my learned friend, Mr. Young, on behalf of the Commissioners. My submission is that if, at general law, the proper interpretation of the claims is that Carlton purported to act on behalf of the Taylor-Clark VAT group, and if Carlton's acts were thereafter competently ratified by Taylor-Clark, then Taylor-Clark can rely on those claims and is now entitled to payment. On the other hand, if the proper interpretation of the claims is that Carlton did not purport to act, or purported to act for its own benefit, then my submission does not succeed. My submission is going to be divided into three parts. The first is the proper interpretation of the claims. The second is ratification. And the third is the issue raised by the appellants as regards the effect of payment, whether payment to Carlton, if Carlton's acts were ratified, also counts as payment to Taylor-Clark. Looking first then at the proper interpretation of the claims, my submission, of course, is that as I think Lord Mance set out earlier this morning, that is a question first as regards findings on fact, what the terms of the documents were, and so on. But once those primary facts have been found, in the same way as the interpretation of a contract, the interpretation is a matter of law, and as I think was Lord Hodge mentioned, there is a right and a wrong answer, and it's open to this court to find it. That was the approach that the Act Revision took, and they were correct to view it in that way. The starting point for interpretation is that an objective approach must be taken so that, for example, Carlton's subjective intentions in submitting the claims are irrelevant. In my submission, that extends, for example, to the commercial purpose of Carlton. The question, I think, was asked by Lord Mance, of what purpose could they have been pursuing other than a payment to themselves? And of course, it may have been that if an agent is acting, the purpose is to get some benefit from one's principal. But in construing the letters, any objective observer, or indeed HMRC, would not have any idea of what the commercial subjective purpose of Carlton was. So my submission, those sort of issues must be left out of account.
I think it's a bit unreal to treat Carlton as if it's some jobbing agent seeking to get a small commission.
Well, certainly, Lord Monken.
I mean, the reality is that this is a big concern which is only going to do something which is of direct interest to it, or possibly fairly direct indirect interest. i.e. it's going to get some benefit.
Yes, my lord. Now that we can look back, and now that any observer knows that Carlton had not informed Taylor Clark did not know about it, Taylor Clark did not authorise in advance, one can quite imagine that the commercial reality was that Carlton was, one might say, walking a sort of tightrope, putting forward a claim that was due to someone else, but trying at the same time to seek payment for itself. But one can see now with hindsight that in light of circumstances not known to an objective observer at the time, yes, Carlton was looking to benefit itself by receipt of the payment. But that is, in my submission, not a matter that can be taken into account.
Well, the point I'm putting is that if it's really fairly clear from the letters that seems to be likely to have been the position, that's an objective fact, which...
Yes.
Yeah.
Yes, my lord, yes. If one looks at letters, and that seems...
Yes, I don't think there's any dispute as to the rules of construction. We look at it objectively, having regard to the factual matrix as found in the findings of fact below. But we can't look at any facts which post-dated, you would say, the writing of the various claims.
Indeed, my lord.
Yeah. Right, so that's construction.
Yes, as regards the actual terms of letters, I adopt the submissions that my learned friend Mr. Scory made. One or two other points. The learned friend Mr. Young referred to a finding, in fact, by the first-tier tribunal that Carlton was seeking a payment in its own right, but in my submission that is a matter of law. That's precisely the question of interpretation for the present court. The absence of any instruction is also, in my submission, of any prior instruction by Taylor Clark or authority to make the claims is also irrelevant, because that is not something that would be known to an objective observer, and is something that perfectly normally arises in cases concerning where ratification is required. Perhaps the point that I should touch on in a bit more detail is the point raised by the appellants that if Carlton were acting as the agent for the VAT group, it was doing so only ad hoc. And I understand this to be a submission that the fact that Carlton was not generally authorised to act on behalf of the VAT group makes it less likely that it was purporting to act as agent in this particular case. Now, I suppose in the first...
I don't think that was the submission. I think it was dealing with a possible submission that you were suggesting some sort of, or you might be suggesting some sort of ad hoc agency, I thought. Anyway, carry on.
Yes, well, that is ultimately what the respondent's position is, that there was, at least Carlton purported to act as, if one wants to use the term ad hoc agent in making these claims.
Yes.
One can. It's not a particular term recognised by law. My learned friend Mr. Young referred to, I think, three cases in his written case, and if I could take your lordships to first the case of Whitbread, which is at manuscript number 968.
958.
968.
968.
Misheard you.
Lord, at tab 33.
I don't think he actually, he took us to only one of these cases, and query how far we're going to get with them.
Yes, my lord. I would only take your lordships to paragraph 13 on page MS 972.
All right.
And if I can ask your lordships
13972, yeah.
To read that paragraph.
It's a rather odd example at the end. I mean, paying somebody else's debt is a pretty risky thing to do if you don't have authority. What can you infer from the mere fact that you do it that there is an agency, or what is he inferring? That he's purporting to act as agents? Ratification doesn't seem to be relevant here. There's no way that the debtor is going to ratify you. He'd be delighted you paid his debt off. At least he's unlikely to be pursued. So.
Yes, well, one can see that in the normal case, but in this case concerned business succession, where I think the successor to the business paid debts that remained due by the predecessor in title. In the present case, the Lord Ordinary pointed out that if two facts obtain, namely the existence of a debt owed by the debtor and the fact that payments made in order to discharge that particular debt, then agency is the natural inference. Now, in the present case, is in a sense the opposite. One is seeking payment of a debt due to someone else. And the analogous facts are the existence, in the present case, of a debt owed by HMRC to Taylor Clark, and the fact that the claims were made in order to obtain payment of that debt. So in my submission, the natural inference, applying that dictum by analogy, is that Carlton was acting as agent, objectively considered, for the Taylor Clark VAT group. And indeed, it was those 2 points that the money was due to to Taylor Clark, and that payment of that debt was sought, that the extra division considered to be particularly important in reaching its conclusion. And one can see that at paragraph 27 of the extra division's opinion, which is at pages MS 131 to 132. The other case referred to by my learned friend, Mr. Young, was a case of Sterling, and in particular, what Lord Ordinary there considered to be a distinction between ordinary correspondence and formal processes such as litigation or adjudication. But in my submission, all the Lord Ordinary said in the passage in question was that litigation or adjudication required to run in the name of the correct party. The Lord Ordinary did not exclude the possibility of agency, and of course in litigation, solicitors and counsel act as agents for litigants every day, but a summons must run in the name of the party. Therefore, in the present case, Carlton could perfectly well submit the claim as agent, but it had to identify the Taylor Clark VAT group as a principal. And indeed, as my own friend Mr. Scory set out, it did do that by using the VAT registration number of the Taylor Clark VAT group. and moreover, by implication, identifying the bank account attached to that VAT registration number as the destination of the payment it was seeking. Perhaps the only other point to make is that in my submission, the revised claim letter is irrelevant to the interpretation of the claim letters.
All of them?
Yes, Lord, to
Why?
all of them, because the claims, the identity of the person whose behalf the claims are made must be ascertained at the time they are made.
But if you withdraw a claim and put another one in its place, which is what happened,
Well, certainly, in my submission, that's not quite what happened. If a claim is withdrawn, then that claim is no more. If a new claim is put in, then that is simply a new claim, and it has to be interpreted on its own.
as if it was never revised. Is there any authority for that proposition?
Well, I don't have authority for that proposition, but I would suggest that as a matter of principle, if a claim is withdrawn as opposed to amended or revised, then the subsequent document is simply a new claim and has to be considered on its own merits, has to be interpreted objectively in its own way.
I wonder if that's true. We've all been sort of taking it for granted that anything that postdates a given letter making a claim is irrelevant to its construction. But I wonder if that's true. If there's a series of letters and it's at least debatable in what capacity one of the earlier ones has been written, are you not entitled to look at the later ones to see if the point is clarified?
Well, Lord, I would submit that it depends on the context it depends what's said in the later documents. So, if, for example, in the later documents, what is said points to facts that both parties knew at the time of the earlier document, and there's therefore proper evidence of the facts available at the time the earlier claim, the first document was going to be made, then yes, of course, one can look at that.
Well, also say for example, I don't know, I offer to buy your house, and before you accept my offer, I put in a further letter from which it's apparent that I'm actually acting as an agent for Lord Hodge. Would one not then say that can't one have regard to that in deciding in what capacity the first letter was written? Or do you say, well, I'm entitled to ignore that, accept the initial offer, and have a binding contract with myself as an individual?
Well, I think in that context, the answer may be that the second letter, which sets out that actually, if when I said I offer to buy your house, I meant that I offer on behalf of someone else to buy your house. And that is, in law, a different offer because it is a different party. There cannot be any, for example, consensus in Edom when there are two different people said to be going to buy the house. So,
well, if I say feel for revenue, and I say I claim the tax overpaid on my bingo halls, and then in a subsequent there's correspondence going on. In a subsequent letter, I say I refer to the claim in terms which make it clear that I was actually making the claim on behalf of another member of the same group of companies at a relevant period. Do you just ignore that?
Well, in my submission, that doesn't affect the proper interpretation of the initial
They do ignore it.
claim. Yes, in interpreting the initial claim that is put in, and if the proper interpretation of that was that the person was acting as agent for someone else, then a subsequent letter can't somehow change that situation so that earlier they were not acting as agent of someone else. In any event, I suppose the curiosity is that in the present case, that the revised claim is only in relation to one of the 4 claims, and it was in fact the revised claim that was paid out to Taylor Clark, which at least suggests that from the appellant's point of view, they nonetheless understood the claims to be seeking payment to the Taylor Clark VAT group.
Well, is that right? Because, I mean, the right to deduct is explained on page 389 in very general terms. It's explained on the basis that Carlton, then known as Leisure Bright, received the whole business undertaking and assets of CAC Leisure Limited, and that apparently must include the relevant trading of CAC Leisure Limited since 1973, one presumes. Yes. And then secondly, it asserts the triad timbers point, that deals with the period of membership. So both those points are general points, aren't they, as relation with regard to all that over-declared? There's no reason to limit them to added prize money or participation fees, is there?
Well, the only reason would be that the letter itself relates only to added prize money and participation fees, but yes, one can see that those points.
It just happened. This letter it was written because I think some need to revise the figures, wasn't it? But the actual substantive explanation applies to all 4 previous letters.
Yes, which suggests there was considered to be a need to give an explanation because the previous letters possibly were regarded as indicating that the claim has been made for the benefit of the VAT group. And the same explanation could likewise have been given in relation to the other claims by separate letters.
But there wasn't any need to amend the figures with the other letters, so it would be assumed that this was a general statement of Carlton's interest.
Lord, one supposes it might be capable of being read like that, but in my submission, the fact that the rest of the letter is confined to the added prize money and participation fees claims means that it cannot affect the other claims that have been put in.
Yes, well, at least you can say this, that while it may be that the letter in 388 to 392 must supersede the earlier claim because they are putting in consistent figures. So it is for the same claim. You say the other letters stand on their own.
Yes, my lord. Yes.
Yeah.
That's all I want to say about the proper interpretation of the claims. So the second part of my submissions is ratification. Now, in my submission...
We've had your half hour, so you better be very quick about it.
Yes, my lord.
Is it open?
My lord, yes, because the approach to ratification is the same as the approach to interpretation. One looks at primary findings in fact, and whether ratification has taken place is an objective.
But you've never argued this, and do we have any primary findings of fact?
Well, Lord, we have primary findings in fact that consist of, for example, the application by by Taylor Clark for a review of the assessment requiring repayment of the sum that was paid for the added prize money claim.
Yeah, but what we have is quite an unusual situation. We have a vigorous assertion on your part that there was no purported agency even in the lower courts.
But
And now you're asking us to assert there's not only a purported agency, but a ratification of it. We haven't got any findings about that at all, have we?
no, my Lord, but in the first place, in the lower courts, the case for the respondents was put basically on the basis that my learned friend has set out. In the present appeal, the extra division's conclusion has been attacked on the basis that they were talking about agency at general law, and there is no basis for ratification, and ratification couldn't competently be made. So, in a sense, all I'm doing is replying to points that have now been raised by the appellants.
But you're not allowed to reply by new material, are you?
Because the fact is, all the way to the upper tribunal, your position was that you had not authorised this claim at all by Carlton, and that you had a separate claim, perhaps based on Mr. Scory's submission, I don't know, but that you never asked anyone to make any findings of fact that you either contemporaneously or retrospectively authorised or adopted that which Carlton had done.
Well, my Lord, all along, the respondent's position has been that it was entitled to rely on the claims put in by Carlton.
But not based on any claim of agency.
That's correct. There have been various different other arguments made.
So when do you say the ratification was?
Ratification was, in my submission, so far as the claim that was paid out is concerned, on the 14th of September 2009, by making an application for review of the Commissioner's assessment that that money should be repaid. That's at MS page 422. It's not in the printed version because it's in part 2 of the appendix. It's only in the memory stick.
Where is that? Sorry, what's the reference?
MS 422. And so far as the other 3 claims is concerned, by letter dated 4th May 2010, 4th of May 2010, which is at MS page 429, by which KPMG, on behalf of Taylor Clark, sought payment of those other claims. That's MS page 429 again.
Unfortunately,
we don't find this. We run out of.
Yeah, we don't have MS numbers for the hard copy of the appendix. Do you happen to have page numbers?
Yes, well, I think that these pages do not appear in the hard copy of the appendix because they're only in part 2. So they're.
Well, I found the request for review on 14th September 2009. That's at page 312 of the appendix. It's internal numbering.
Yes, sorry, my Lord, that's right. My numbering is quite different.
I think if you add 110 to the internal numbering, you get the MS number in every case. So 319 is the letter which you're referring as 429.
Yes,
it is.
Yes, that's right, my Lord. That's the letter of 4th May 2010.
These don't look like ratifications. They look like Something else.
No, my lord. So they,
Assertions that money.
Implied ratification.
Yes.
yes, my lord. So that's precisely.
They
the
don't
point.
seem to deal with the claim at all. They're
Doesn't-
just dealing with who's entitled to the money. They assert that Taylor Clark is the person entitled to the money.
Yes, and thereby, in my submission, the proper interpretation would be that there was an implied ratification of whatever
Of an agency arrangement which you denied at the time existed. I really don't see how you can get...
Well, yes, Mark, but the subjective
Yeah.
view of Taylor Clark and regarding no agency as having...
Did Taylor
existed
Clark even know about Carlton's letters at this stage?
At that stage, my lord, yes, I think they must have known about the
What, by May 2010?
letters. Yes, I think so, my lord. Certainly, they knew about the first inkling they had was when they received
The money.
payment in
was
May
the manner.
2009.
Yeah. But how do we know, bearing in mind they're only starting to sniff around in relation to the other claims in May 2010, that they'd had the correspondence? I mean, either way, it's very odd. If they didn't know about the letters, it's quite hard to see how they could be ratifying. If they did know about the letters, it's quite hard to see why they aren't referring to them.
Yes, my lord.
Anyway, that's
Well, yeah. Well,
I think you really must keep going. But any alternative ratification dates?
well, certainly, my lord, the dates of the appeals to the first tier tribunal.
Well, that's subject to the same problem, isn't it? I mean, you were actually denying any agency.
Yes, yes, my lord, I can quite see that.
So, I mean, what about now?
Well,
We can't start digging around to that extent. And you've done the best you can, and you have to take it for good or ill, but you can't sort of start digging around beyond certain stage.
Anyway, how much more? That was really your third point, wasn't it?
No, the effective payment is the third point.
Oh, sorry. Are we?
yeah. Well, apart from that, I should say there was, until this morning, the appellants hadn't taken any point about
Yeah, sorry. That's
the facts not being sufficient to justify an act of ratification. The point that was taken was that ratification can't take place beyond a time limit. Taking that as briefly as I can, the question there is, looking at the case of Alexander Ward against Sanyang Navigation Company on the one hand.
That had nothing to do with time limits.
Well, my lord, that was described as, for example, by Lord Brandon as a type of time limit. That's it.
Well, he was talking about the limited effect of arrestment ad fundandum jurisdictionem.
Yes, Lord, which had to be.
Yeah, it was a question whether the effect of the arrestment ceased once the action began or whether it had some continuing effect.
And also, as I understand the Revenue's position, they are not arguing the time bar as a bar against ratification point today. Mr. Young expressly withdrew
In that case-
because he said, and I think rightly, that it involves complexity, which certainly in my book should have been addressed by the courts below if it had been argued below.
Yes, well, my lord, if that's not now being made against me, then I'm happy to move on.
Well, I'm not sure. I think he is being held against you. I think he's saying that he wasn't proposing to argue it because he objected to it being raised at this stage.
Yes, the point wasn't being conceded.
Well,
The point being made was this has never been argued. It's quite an important point of Scots law, which involves us being asked to overturn a decision of the inner house that stood for 100 years. And isn't the time or the place to do that?
yes, well, that may be true, but that's the point that the appellants took in their written case, so I had come at least prepared with an answer.
And your answer is Alexander Yard award against Sun and Navigation, which we can read.
Yes, my Lord, because the point there was that arrestment had to be effected before the summons was served. So although there was not a time limit which was a date, there was a time limit which was an act. There was a chronology that had to be observed. If the arrestment was served after the summons was served, there was no jurisdiction. And the House of Lords said that as long as the proceedings hadn't concluded, ratification could be granted.
Where did this ratification point emerge? Because your case isn't dated, but it has a section dealing with ratification, and the other side's case isn't dated, and it also has a section dealing with ratification. Which came first?
The appellant's written case, more, which I think was in 2013.
So that really they gave a hostage to fortune, and you jumped onto the bandwagon, did you?
Yes, so
Had it been raised in correspondence or something? I was wondering where the revenue had obtained the ratification argument from.
I certainly don't recall it being raised before.
No, I mean,
the appellant's written
you
case.
didn't actually serve a respondent's notice on it, did you? To say that the decision should be upheld if all else failed on the grounds of ratification.
No.
No, well.
So the first time it became clear
Well, I
was
think
initials.
maybe you could argue you could just do it in your case, but I rather doubt whether that's a very satisfactory way of doing it, especially if it isn't raised before.
Well, well, all I can say is that as far as my recollection goes, the first time an issue of ratification was raised was in the appellant's written case, and I'm simply responding to that objection that has now been made. So far as Goodall is concerned, the case of Goodall against Bilzen, which is one on which the appellants rely, in my submission, what is said by, in way of reasoning, suggests that the time limit is the final determination of the proceedings, because the Lord President talks about ratification being too late once matters are no longer in dubio. In other words, one can't wait until the coin is landed before one shouts heads or tails. But what Lord President Dunedin said was that it was no longer possible to ratify because the time limit for appealing had expired. On the other hand, Lord Salveson, in passage in his opinion at MS 689, if one reads that, there are 4 different possibilities as to when ratification is no longer possible. That's the time limit for appealing, after some reasonable time, after final determination, or simply not at all, because when an appeal that was not authorised at the time it was lodged was a fundamental nullity. Pardon me. In any event, my Lords, on that, my submission is that ratification remain possible, notwithstanding the expiry of the time limit under Section 121.
Yes. No, well, you've set it out very helpfully in your case, insofar as we get into it.
The final part of my submissions is the effect of payment, and I don't think I need to say much more than that granting authority by ratification for making claims, my submission in general cannot be objectively interpreted as granting authority for the future to receive payments. Certainly on the facts, by the time payments were made by HMRC, which, as I understand it, was sometime in early 2012, any such
The parties were at each other's throats as to who was to get it. So you say that there can be no inference of a continuing authority.
Yeah.
Precisely, my Lord.
Anyway, the point of ratification is you're ratifying a claim on behalf of yourself, not a claim to be met by payment to someone else,
Yeah, certainly.
even the person who is making the claim. Yeah.
We ratified the act of making the claim. We did not grant authority to receive the money.
Right, that's very succinct.
So, unless I can be of further assistance, my Lords, I would invite your Lordships to allow the appeal, to refuse the appeal on the grounds I've set out, in any event, over and above the grounds my learned friend Mr. Scory has set out.
Thank you.
I apologise for being slightly longer than I anticipated.
Yes, Mr. Young.
My Lord, in the time I'll try to confine myself, I think, to Mr. Scory's arguments, unless there are particular points that arise out of the common law agency issue that my Lords wish me to address. I think the starting point in my response is to note that, of course, the legislation from the European Union on VAT groups is, as we've seen, very brief. So Article 11 of the PVD, very short, permissive section. It is not directly effective. I'll give my Lords the case on that. It's not in the bundle, but the European Court has held that it was not directly effective in the case of Larentia, Larentia, and Minerva. And it's 2015 Simon's tax cases 2101, and it should be at paragraphs 47 to 51. And what the legislation does is it leaves considerable discretion on the part of the member state to put the model in place. So Mr. Scory says that the model here is wrong, as I understand it. But what we say is that the EU has set out the general scheme, a very general scheme, and then it's up to member states to apply their particular model to give effect to that. There's fairly extensive discussion of this in the upper tribunal decision in MG Rover at MS 918, MS 918, which should be tab 28.
It's in tab 28, I think.
Tab 20.
28.
28, yes.
But starting at 162.
Yes.
No, it's starting at 883, isn't it?
Sorry. Paragraph
Oh, I see.
162,
Paragraph
MS, page 918. Yes.
Yeah.
Now, my Lords, this whole section here under discussion, 162, certainly through to 175, is worth reading, and I'll simply leave my Lords to read that later.
Basically, it's making the point you just made.
It is. It's going through it in
Margin of discretion. And,
indeed. And perhaps just one or 2 points to emphasise paragraphs 172, which I think we have looked earlier. If one looks at the very second last sentence there, which talks about simplicity permits construing section 43 in accordance with its terms as providing that only the representative member has the rights of a taxable person for the purposes of the Act. So that's in general, looking for the purposes of the Act. 173 and 174, 175 then deal with this in the context of section 80. And if one looks at the last sentence in paragraph 173, thus the Act provides only the representative member with the associated rights to make a claim under those provisions. And then 175, we conclude therefore that a construction of section 43 and section 80, under which the only person entitled to receive payment in the section 80 claim is the representative member for the time being. And if one goes over the page then, this is MS 920, paragraphs 177 to 178. In this section, the upper tribunal is saying that there's a two-stage process. This first stage is, as I understand it, effectively the stage where the HMRC will deal with the representative member, and the second stage is when the representative members and divide out the claim amongst themselves. If one looks in paragraph 178, that first sentence, no, sorry, it's the second sentence, perhaps I'll leave my lords to read that. And the emphasis there being, it's the rights are exercised through the representative member, it's not the right of any particular one of them to make the claim.
What was the issue there? I mean, were they concerned with the same issue as we have?
These were conjoined cases where, far more complex, there were claims for, as I understand it, former members and claims for representative members. There were conflicting claims within the litigation. So it is essentially...
And how do you fit that in with the case on where the representative member is wound up? The JNW Waste case.
My Lord. The situation of a winding up has always been seen as being an exceptional circumstance where there would have to be an exceptional San Giorgio right would have to be fashioned. And that's been discussed, it's mentioned, certainly I think it's mentioned somewhere in MG Rover, I forget the actual paragraph, and it's been discussed elsewhere. Where you have there's no representative member left, then because of the European nature of the right to repayment of overpaid VAT, the HMRC would have to fashion a remedy.
Would you not, I don't know, but could you not restore the former representative member to the register?
There might be ways of that. If that was not possible, there would have to be some San Giorgio right, no doubt, to the real world supplier fashioned. But those have always been seen as exceptional.
But what is the provision which precludes the situation you had in JNW Waste, and why did you need to have anything artificial?
Well,
as long as an interested person makes a valid claim, what's wrong with that?
Well,
I mean, because Section 80 doesn't say it's got to be a claim. It just says a claim has got to be made for the purpose, as long as a claim is made for the purpose.
But it has to be for the purpose of a payment to the person with the entitlement to the claim. Now, if the representative member is the person who has accounted for the tax in the past, they are the person with the claim. If they are no longer there and cannot be brought back onto a register, there would have to be some exceptional remedy.
So what I find difficult to get my head around is the fact that you can the representative member can change
Indeed.
month to month.
Good.
But the nature of the entitlement and the liabilities and the claims presumably doesn't change. That belongs to the notional group. Well, and it's not affected by the fact that the representative member changes.
The representative member is seen as some sort of continuing body, really. So if a new representative member takes over, they simply inherit. They succeed to the representative member's rights and obligations.
Yes, but not by virtue of anything the statute says, but simply by implication.
By implication.
Because under the Article 11, that's how the thing works.
Indeed.
Which seems to me a very good point being made, that you can't just read Section 43 literally. It's got to be giving effect to a notional set of liabilities and rights in the group.
Well, I suppose the principal problem that we see in the respondent's analysis is that it would mean that you have this sort of collective body of members and former members, all with potential rights to make claims in a Section 80 situation. So one could have a multiplicity of claims coming in because, of course, former members may have very different interests from the current member.
But that's assuming that the right to make a claim is the same as the right to the payment. But I mean, if what you're looking for is a valid claim, the question of who's entitled to payment may be a quite different issue. Once you've established the right to the repayment, then you can have an argument about who's entitled to it. But it doesn't need to be tied up with who's able to make the claim.
perhaps I could take one step back. The policy behind VAT groups in general has been said to be simplicity of administration. I think, Lord, that was said in the Thorn Materials case. It's picked up again here in the MG Rover case. Now, that simplicity of administration is not enhanced if HMRC have to potentially look at claims coming from a number of different sources rather than the single source, which is the representative member.
And the representative member, I mean, my Lord's question could, it seems to me, be answered by treating the representative member in the same way we treat a bishop as a
corporation cell.
As a corporation cell. There's a continuing.
Well, that's an attractive idea, but you've got to read pretty hard to find that in the legislation.
Maybe it has to make sense. It only makes sense in that way.
Can we look quite closely at who the person is in the last line of section 80 sub 1? They shall be liable to credit the person with that amount. Now, if there's been a change in representative member after the original accounting and before a claim is notified so as to trigger this liability, at first sight, the person looks as if it means the same person who was accounted under little a, or has been assessed under B. It probably includes all their successors or assigns, doesn't it?
Yes.
So that would include both a successor representative person who had succeeded, like the bishop, to all the responsibilities of his predecessor, but also someone to whom, let's say, a liquidator of the last representative person had assigned the relevant rights in an administration, for example.
Indeed.
Sorry, administrator rather than liquidator.
Yes.
And it really, as I was trying to point out to your opponent earlier, if one were to adopt his approach and look at the VAT group, that itself is like an amoeba. It's fluctuating in size, and it's not a single stable entity. It may acquire and lose members, so that you have to have this concept of succession one way or the other.
Indeed. So what I say is that the European law sets a very simple framework. UK law has adopted the concept of a representative member. That has been considered in cases such as MG Rover as simply being compliant. There have, as I understand it, I'm told that different member states do adopt different models. Whether anyone has exactly the same model as us, I do not know, but it does actually happen.
I mean, such a simple and easily operated model.
But the problem about simplicity is that it's quite clear that the legislation wasn't constructed to deal with the sort of extraordinary situation we have here, with claims being made 10 years after the relevant time as a result of the law having been got wrong for 15 years or so. I mean,
Indeed.
so we can't be surprised if it produces a slightly weird result.
Indeed.
We should try and make sense of it, or achieve
Does it,
a less weird result.
Does the built-in uncertainty and sometimes forensic need to find out who is the person who should be paid under section 80 sub 1 credited support a view that the requirement for the making of a claim is procedurally no more specific than the literal words of subsection 2, a claim must be made for the purpose, without it saying anything about who has to make it, so long as I suppose the person isn't a complete busybody.
Well, that's taking us back to the arguments that was the argument for the first tier, before the first tier tribunal and the upper tribunal for the respondent. There simply had to be a claim, including a busybody. I can remember that example being mentioned, and a busybody would do under that analysis. No, what we say is what for the purpose must be for the purpose of crediting or paying to the person under section 81. So it has to be made by or on behalf of, in this instance, the representative member. perhaps one of the other criticisms that might be levelled against this concept that the respondents rely upon now is this. To what extent can a past or a present group member deal with the claims for on behalf of a single taxable person? Is it only, as I understand it, the making of the claim? Or does it go further? Do they also have the ability to mark the appeal? And if they can mark the appeal, does it also extend to receiving payment of the claim? Because it does seem to me that there is within that submission the seeds of its own destruction, that if you can see a former group member as embodying a single taxable person to allow them to make a claim, on that basis, why can payment by HMRC to that former member not be seen as being payment back to a single taxable person? It's the same. It's a very similar point to payment under the agency. Would that not amount to discharging the payment or the obligation?
Well, I think the argument against that is that it's got to be a claim to the person who's accounted. Sorry, a repayment.
Indeed, but one of the arguments in the written argument for the respondents is that, properly understood, the person who accounts for the VAT is a single taxable person, not the representative member. I think that's...
On the question, who must the claim be made for the purpose by, subsection 3 postulates, doesn't it, that the person making the claim is the person to whom the payment will be made, because it says it shall be a defence in relation to a claim that the crediting of an amount would unjustly enrich a claimant.
Yes. So the claimant is aligned there with the... Yes, indeed. My Lords, in the written submissions, various justifications have been given by the respondents for why they say that their formulation is appropriate. It's said that the group member who has the records may be best placed to make the claim, in my submission, that whilst still within the group, it will always be the representative member who deals with HMRC, and the representative member surely is best placed to coordinate any adjustments that need to be made to the group VAT return. It's said that the group member may have left the group and there may now be difficulty to get cooperation. That seems, in my submission, to be an argument against allowing the former group member to make a claim if they're not cooperating with the representative member. There is also reliance upon, it said, various EU principles of effectiveness. The principle that there must be a remedy for repayment of tax must not be impossible or excessively difficult to obtain. Well, in my submission, we're not in that scenario here at all. The only reason Taylor Clark did not make a claim in time has nothing to do with the legislative structure. It's simply because they did not, in fact, realise that they had a potential claim. Now, my Lords, I wonder if I could just give my Lords also some references to passages in the Thorn Materials case. That's the House of Lords case. That we've seen one or two passages, and if I could just direct my Lords to some other parts. Starting with Lord Nolan's speech at MS 623. C to D. We've seen various sections here, and just underneath the reference at C to D about simplification, just ask my Lords to read on, and one can see there that the representative member is treated as carrying on the business of the other members and dealing on behalf of them with non-members. So Lord Clyde, who also gave a supporting speech, page 631, paragraph starting between letters G and H. talking there about section 29, and he says it doesn't destroy the identity and existence of the members, but importantly, nor embrace them all in some unified single taxable person, which seems to be similar to the concept that the respondents are relying upon. And Lord Hoffman, who actually dissented in this case, but he did have a short description of the purpose of section 29, or the mechanism of section 29, at MS 628, between letters A and B. And at that point, what Lord Hoffman is saying there is that section 29 produces a single taxable person through the representative member. And then, interestingly, he says it doesn't do by the crude method of deeming all members to be a single person.
Which, as we shall see, has startling side effects.
Yes.
Oh, what are they?
I have to confess, I read through and I couldn't immediately see what the startling side effects were in the rest of his... But we can see, at least conceptually there, he's saying that one doesn't deem the members to be some part of a collective, effectively, I think, to use Mr. Scory's words.
Probably the previous page.
I think you can say that Lord Hoffman's analysis of the effect of section 29 and his rejection of a black box theory
Yes.
is, I don't think he's at odds with the other members of the committee on that aspect. It's rather when he comes, it's rather the effect of the timing provisions in section 5 about supplies, I think, on which he takes a different view from the other members of the board. In a situation where somebody has left the group at a time after a supply under section 5 would have been deemed to have taken place.
Indeed. Melrose, I'm conscious of time. My submission really trying to draw this together in terms of the main core argument for the respondent is simply the UK legislation adopts a particular formulation of representative member who embodies a single taxable person. It is not at all obvious from the EU legislation or any of the cases from the European Court, none of which touch upon issues of members coming in and out of VAT groups. It's not obvious that representative member model is inconsistent with European law. Once one has that representative model, which is there for simplicity, the Section 80 claim will, in almost all cases, be the representative member or the last representative member's claim. So any Section 80 claim should be made by them or on behalf of them. And whilst in theory a group member could be appointed as agent to make the claim on behalf of the representative member, absent that particular appointment, one would not see a claim coming in from a member or indeed a former member as being a claim on behalf of either the single taxable person or the representative member.
Does the correspondence show any reason why Carlton didn't inform Taylor Clark? Has that ever been explained or investigated?
No. I confess I don't know the answer to that. I've never seen any correspondence. I'll also realise that very much this case we have seen the Taylor-Clark papers. There are separate Carlton papers which have not. Matters are dealt with for reasons of taxpayer confidentiality are often dealt with separately. So I have not seen all the papers for Carlton's claims.
Can I just ask you, the point Mr. Story made about, which goes to your sort of simplicity point, he said that in a big group there may be very small companies and someone operating down in Cardiff, I think he had, who might be dealing with it, and that might deal with it entirely separately from the group as a whole. And as a matter of practicality, as long as he gets the right VAT number, then it's all dealt with and it all comes out in the wash, and no one would say, oh, you can't put in the claim from that small group because, or that small company, because it's not being done by the right part of the group. Is that a valid point? I mean, it seems to me that I think one of the strongest points he made, seemed to me, is the fact that as long as you've got the VAT number of the group, that's really what the revenue needs to make sure they've got a proper claim, and as long as they've got that, then nothing else matters very much.
Well, I suppose the question would be, was the group member's claim accepted by HMRC to be actually really a claim on behalf of the whole VAT group rather than simply that one member? That's probably in many of these cases a practical issue.
Yeah.
Would be, do you agree that your member is acting for the representative?
There may be a degree of flexibility in practice, but it doesn't really cause problems.
Yes.
Thank you.
My Lords, I'm not sure there's very much I want to say in relation to issues of... in fact, just on ratification, can I just make two very quick points? On ratification, this was raised for the first time in our written case, which would be a couple of months ago or something like that. But that was simply because the extra division raised agency for, in our view, the first time. And it was while we were preparing the written case, it seemed to us that the proper analysis, if there was any agency, could only be done by purported agency followed by ratification. And so that's why it comes late in the day. And I think I should just be quite clear what my submission is on the time limit. What I indicated was that the written case, we've referred to the case of Goodall, which is an inner house case on ratification after time limit not being allowed. My learned friends have referred to a number of English cases which appear or may take a different view. And my position was I didn't think it was appropriate to make a submission to the court, asking the court to take a final determination on ratification which would overcome a limitation period, because I don't think we would be doing it justice in the time available. So I think technically I've not really made a submission on ratification and the time limit. I have made the submission, but there's simply no evidence of ratification.
Well, I mean,
That was my understanding of your
Yes.
position.
I understand your position. It's slightly odd because you really should have asked for more time, and you have taken the point in your case without making that sort of technical point. If there's not time enough to argue,
Yeah.
I understand, having heard the arguments, why one might think that, then you should have asked for more time. You couldn't say in your case, I object to this, even because it's an entirely new point, and I think we've pointed out that one might need some facts.
Indeed.
But it's not a wholly satisfactory position.
My Lords, unless there's anything further I can assist with, I'd simply make the motion that the appeal be allowed.
Thank you very much indeed. Well, we're, of course, very grateful to Council for their submissions, and we'll take time to consider its judgment, which will be handed down in the usual way. The Court's adjourned.